All right, we're back. Thank you so much for sticking with me. This is the third of three mini units on constitutional context of discrimination as it pertains to race. And this will also conclude all 6 of the discrimination videos. So thank you so much for bearing with me, for sticking in there. And what I plan to do with these next few slides is we're going to move somewhat rapidly now. I think about 6 slides or so. We're going to look at 4 cases and a variety of other things. Picking up where we left off, we were taking a look at the KKK and racism and white supremacy. Okay, so now we're going to take a look at some cases here. Probably one of the top 10 most famous constitutional cases is Plessy versus Ferguson. So the question that came before the court in 1896 was, is the separate but equal seating qualifications, and that's kind of what was used in this Louisiana statute on public transportation, a violation of the Constitution. So a little context here. In the late 19th century, of course, in the wake of these Jim Crow laws, many southern states created their own interpretation after the federal authorities were removed after Reconstruction, and their own interpretation of the Constitution. And so some of these differed wildly from those applied in the North. So they did have these restrictions that had to do with one's alienage. To what degree were they mixed race? And in Louisiana, in New Orleans in particular, it was a very cosmopolitan city before the Civil War and after. And you could be mixed race even in the late 19th century and still be very high class, high status, be rich, even own slaves up until of course, the Civil War. And so these were very well-regarded people who might have had a grandparent who was black or something like that. And of course, it's more complicated than black and white, but some of these laws define that in a very simplistic and reductive way. So we have this challenge that went all the way to the Supreme Court about separate streetcars, that those who have any descent that is black, 1/8 or more black, would have to sit in another seat, and whites could sit in another one. I guess, and so that concept of separate but equal had been a common law and legal term for a long time in the South. So this finally came to a head when the Supreme Court decided on this. And what do you guess that they said? They said, no, that's not a violation of the Constitution, back in 1896. Which might strike you as a little odd, but maybe we're just reading that from our own perspective. But the rationale here is always important, because always, remember, look at the majority opinion, but also the dissenting opinion. Sometimes it's the dissenting opinion that is ahead of the curve in terms of our knowledge about science and about ethics related to other people. That this is an example of that. So the majority opinion argued that the intent of these laws was equal treatment, but the effect may or may not discriminate. So they said, we can't really say, but we do see that the law tried to at least be equal or be fair. They also said that there's a compelling public interest. It's important to keep people separate for any number of reasons. I think what they might have implied is keeping the races separate for reducing violence and social conflict, perhaps. And separating people based on their background might actually have a rationale. I don't know if that's a very strong argument, and you probably disagree with that, as I do, but that was the logic back then. The public peace and good order are important public interests. And so the Constitution is interested in rights, not necessarily the effects. They said, well, look at what the Constitution says. It doesn't promise that the effects are going to be great, but it does promise to build laws based on these basic principles, right? Your rights. So is this a reasonable classification? The court in 1896 said yes. But here's the dissenting opinion by Justice Harlan. He says the Constitution very famously, this is a great phrase that sort of reverberates through the 20th century, the Constitution is colorblind, right? It doesn't pay attention to color except when, and it's our job to kind of look at the effects of implementing an interpretation like this. In other words, it's a suspect classification, because why would you have to separate these people? You might make an argument that it creates peace, but it can also create a lot of problems, which we'll see in this case. So this is a case, a very clear case, about 50 or so years later, of one principle of a previous case in stare decisis being totally overturned and dismantled. And this was a unanimous case in a 9-0 opinion. A young Justice Thurgood Marshall, who would later become a Supreme Court Justice, the first black Supreme Court Justice, was the lawyer who argued this before the Supreme Court in 1954. And he worked very hard to make sure that there was unanimity in this case, so that it sent a very strong message in this period of time. So to make a long story short, the Brown versus Board of Education, there were actually two cases that were conflated at the time and argued at the same time. But the question was, does segregation of school children, keeping these basically separate but equal based on race, deprive minority groups, in this particular case blacks, in Topeka, of equal opportunities? And here, the court said, yes, that does deprive them of equal opportunities. It's unconstitutional. So it's a suspect classification. So they finally, decades later, listened to the dissenting opinion in Plessy. They said there's no rational basis for that. We interpret the 14th Amendment not based on intentionality, like what the law intends, but what are the contemporary effects? What's really going to happen if you segregate school districts? You have a black school district and a white school district. Look at what's going to happen. There's going to be de facto discrimination. And so this is really interesting. This is not what the Constitution says, but how we might want to apply it. So as you might expect, not just because of the racially charged moment and the conflicts and controversies of the 1950s was this controversial, but it's also because they're introducing a new concept about looking at the practical effect on the culture. What is this really going to do? Not what does the Constitution say? What did the framers of the Constitution really mean by this particular language? But what's it really going to do? So it should not apply to education. That should be something that is not affected by these kind of arguments that are related so tightly to race and racial history. They said also you can look at the circumstances, the effects, the practical applications. Separate does not mean equal in this case. Separate means unequal. They're going to be treated differently and not equally. It's going to be have and has had profoundly bad effects on disadvantaging some people. So one of the controversies was this term called judicial activism. That some people felt that the court went too far and they are actively, creatively interpreting the Constitution and basically having the effect of creating law as opposed to just weeding through the constitutionality of certain laws. And that's an argument made by some and have been ever since. This also resulted in what's called desegregation for the next few decades. It became a federal mandate to make sure that schools integrated, even forcing that and even busing people of different ethnic and racial backgrounds so that there's not segregation, even de facto segregation. So fascinating. So we get to the badges of slavery, the quote-unquote badges of slavery. We'll talk about this in another slide very soon, too. But this has come to mean the symbols, the legacy, the residue of slavery. So slavery's been gone for a century by this point, by the 1960s. It's gone. It's banned. But there are all these other things. The Jim Crow laws are just part of that. Voter intimidation, de facto segregation that are the legacies of slavery. And so we start to see these Supreme Court cases challenging what's called the badges of slavery. So under Earl Warren, who's Chief Justice in the 1960s, he tended to express judicial activism over what we call strict constructionism, or strict construction in examining these civil rights cases. In other words, not asking, well, what would these these white slave-holding framers of the Constitution back in the 1790s think about this term, as opposed to what are its practical effects now? Because the Constitution is not for them; it's for us. And so we can still stay true to the spirit of that and the letter of the law. However, we can also take into consideration the practical effects of applying the Constitution in certain cases. So you can see an interesting tension there. So in the civil rights movement in the 50s and 60s, many social and legal factors were at play. And here we see a convict. This is a very, very famous convict who deliberately allowed himself to be put in jail. This is Martin Luther King Jr. And he did this in protest, and there's a whole story behind that, which we won't get into, but you read a little bit about in the book. In 1963, he wrote this famous letter in which he talks about what's at stake with the civil rights era. It's not just a bunch of people who are just upset with the law and they keep writing their Congress people and things aren't getting done. It's a whole philosophical approach in the macrocosm, in the cosmic sense of what's really at stake here in the West and in civilization. He says there are just laws and there are unjust laws. And using the writing of Aquinas and Augustine, these church fathers who are well respected in all Christian walks of life, and their concepts. He also uses this idea of the I-it or the I-thou, coming from a writer named Martin Buber, who said there are some laws that are just morally wrong, even though they're technically correct. He says the job of someone who's practicing civil disobedience is to knowingly break an unjust law and take the consequences, being beaten, being put away in jail for a long time, perhaps. And that actually, ironically, maybe counterintuitively, shows the higher respect, or the highest respect, for law itself. So what this means is sort of a new interpretation of what we call jus civile, that law is meant for us, not for these high principles. Right? So it's a fascinating idea. So there were laws all through the South that did things like this. They prevented a white person from marrying a black person, all the way up until about 50 or so years ago. It finally came to a head in Loving versus Virginia. There's a Hollywood film that came out about 10 years ago about this. I think it's just called Loving. I haven't seen it, but it's about this love story between, actually Loving was the last name of this couple, versus the state of Virginia, and how they got married across one state line, came back, and they were prosecuted for that. So, does a statute preventing interracial marriage violate the 14th Amendment, the equal protection of? And they say yes. So the very nature of that kind of statute that deals with what's called miscegenation, that's a eugenics term, a pseudoscientific term going way back to that first sort of racial science slide I was sharing with you. It's outdated, it's wrong, and it has no place in our laws, is what the Supreme Court basically said. An absolute prohibition of interracial marriage is problematic at best and unconstitutional at worst. They said it's clearly based solely on race. It's, by definition, a law like this is a suspect classification. It violates equal protection of the 14th Amendment and due process of the Bill of Rights. And the appeal to basic and natural rights that you find in the 9th Amendment, it's one of those amendments you skip over very easily. It's about the natural rights of people, and they consider the right to marry as one of those natural rights. And so finally we get to this last one in 1 minute. One of the badges of slavery was this Jones versus Meyer company, in which another sort of legacy of slavery is in many, many cities, including Rochester. It was legal to draw a red line around a map and say we're not going to sell property to black people, even into the 20th century, even into the 1960s. And of course, is a federal statute requiring equal treatment in renting or buying property valid? And they said, yes. So what that means is allowing people to rent and buy property anywhere based on race is of course upheld. So housing discrimination, or what's called redlining in city and suburban realtors, is unconstitutional. So under the 13th Amendment, Congress has the power to determine what are the badges of slavery and to create legislation eliminating them. Thank you very much. This